It's a problem. It's a huge, huge problem. What I'm looking at and what's happening in terms of the expert testimony in the Karen Read case, this is not good. This is not good. It's a big, big problem in a case where you have a battle of the experts, where the experts' testimony is crucial, is absolutely crucial and important. There's no eyewitnesses. You don't have eyewitnesses. So you need to prove to this jury, if you are the prosecutor in this case, how Karen Read ran over John O'Keefe. And you can do that with the pieces of evidence, and then you take the pieces of evidence and you put the pieces of evidence together. And then you tell a story to the jury and you base it upon your expertise in something, in a narrative that makes sense. But now there is a big, big problem for the Commonwealth. And we saw a preview of it today. Because today inside the courtroom, the jury wasn't there today, but the judge was there, the lawyers were there, and three experts showed up for the defense. I'm not going to talk about the first one. The first one, I had a separate opinion on that. But the second two, the accident reconstruction experts that the defense is going to call in front of this jury come into the courtroom with, before they say one word, more credibility than any of the other experts for both sides. Before they say a word, they have more credibility. Because how does the normal battle of the experts work inside of a courtroom? It is simple. Each side hires their experts. Sometimes they work in-house for them, as in like the trooper who testified. But each side has their own expert that they hire and they present. Okay? And that get paid by that side. So if you're a trooper, you're being paid by the Commonwealth. If the defense goes out and hires someone, they generally pay that expert. That expert comes in and testifies. I've seen it hundreds of times in hundreds of criminal cases through the years that I've covered on Court TV. And the battle, so a lot of times, is a wash. A lot of times, the battle itself ends up being a wash because both sides have paid experts, and you take what they're saying with a grain of salt because you know who they're working for, you know who they're getting paid by, right? And then you have to, as a juror, you have to use your common sense and maybe analyze who they are and where they come from, what their real experience is, and just their general demeanor in court. But let's start here. These two experts talking about in analyzing the evidence to determine whether or not, in their expert opinion, John O'Keefe was struck by the car. They're not getting paid by the defense. They were not hired by the defense. The first time they met him was today in court. Follow that one more time, please. The defense experts were not hired by the defense. They're not being paid by the defense. These experts are coming into court under subpoena after being hired by another agency. And that's how it'll flow inside the courtroom. But we know the other agency is the Department of Justice and the FBI. That's who they were working for. They go out and they spent, good money, government money, federal money to hire these experts, and just said, "Here, tell us what happened." Because they don't have a dog in the race. Pun was intended there, by the way. They don't, because they're not a party to this case. They were just investigating what was going on, and we're looking at this and saying, "Okay, tell us. You guys are experts. Tell us what happened here." So these experts have been paid, but not by the defense, not by the Commonwealth, by a third uninterested party to this trial. So automatically, they walk into the courtroom before they even say a word. They have more credibility than the other experts in the case, all the other experts from both sides. Okay, that's the first part of it. Now, the second part is who they are and what their experience and background and education and expertise is. These guys are engineers, specific engineers, and together their opinions tell the whole story. One is more on the one is going to deal more with what happened to John O'Keefe based upon his background, education, and experience. The other will be talking about the car and the damage on the car, and then they put it all together. So you've got two engineers who aren't getting paid by the defense, who will come in and give the opinion that John O'Keefe was not struck by the car. Okay, but it gets worse. It gets even worse for the Commonwealth. Unbelievably, right? Like that's bad enough to begin with. That okay, you're independent. You have independence that experts rarely have in a case. They rarely have this independence because usually one side or the other is hiring them. Now, based upon their expertise, they're saying that oh no, this is not consistent, and then just their poise and demeanor on the witness stand. These were like experts. Okay. And I was saying this on the air, and I don't know if I did it in the stream or not. I definitely said it on the air that one of the problems with the prosecution's expert, number one, he's a state trooper. Okay. So that doesn't look good. That doesn't mean he's not qualified. But his demeanor on the stand, he did not control the courtroom. He was not controlling his own testimony. He didn't have that confidence that you want from an expert. I'm the expert. Sit down, listen to me. I'll tell you what this is all about because I've been doing this for a long time and I understand it. That's not what I got from the trooper. What I got from the trooper was he's a trooper. I'm sure he's a fine guy, has got put into this division with the Massachusetts State Police and then began analyzing car accidents and then taking some courses to kind of learn from other experts how to do it. Yeah, I get it, but that's like this level of it. Now, you want to get to the next level, you know, how about being an engineer with a specific expertise in analyzing this stuff in what you do and fully understanding all the words and being able to get on a witness stand, bring that to the witness stand, and then be able to explain it in a way that is authoritative, oozes confidence in what they're saying, and understands everything that they're saying. You want your expert to know more than the lawyers. And what happened to the trooper was, it seemed, because Alan Jackson has been talking to his experts or has been studying up on it and has done this stuff before and was prepared and knew the verbiage, knew the lingo, and just came across, like during his cross-examination, that he knew more about this than the expert. And that can't be. That's when you lose as in a battle of the expert. If it comes across in the courtroom that the attorney knows more than the expert. Now, that's not going to be the case with these two experts coming into the courtroom. I mean, it seemed like everyone was giving them a sense of deference, right? We as lawyers, like, hey, we're educated, whether you're a judge or a prosecutor or defense attorney, we're educated. We know things, but we're not engineers, right? So we know that our expertise stops at a certain place, and there's a general sense of deference to these experts, and that's what came out inside the courtroom. And this is before they're even in front of the jury. So Trooper Paul, and I'm sure he can put together some cases, but the problem he's going to run into in this battle of the experts is that he is outmatched on every level of how you determine um, who to believe or who to trust. His education and experience doesn't even come close to these guys. That's number one. Number two, he's, on the payroll of the Commonwealth as a state trooper. These guys aren't even being paid by the side they're testifying for. So that's number two. And then number three, just the general demeanor and confidence on the witness stand. So that's 1, 2, 3 strikes. This is a big problem for the Commonwealth because it deals with the ultimate issue of having this jury feel comfortable without an eyewitness, that Karen Read is responsible, that it was her car that did it, her SUV with her behind the wheel doing this, right? So now for the Commonwealth, they need to lean a lot heavier on the other evidence, which is, some common sense. The taillight pieces are there and the alleged confession. They have to lean on that because they can't lean on their expert. In their closing argument, they're not going to can they come up there and say, you heard from Trooper Paul? No, they're not going to say that because you're going to have two engineers, independent, who are going to contradict what he said. And what they say, they didn't get into the details necessarily of their opinions today, but you got enough to get a sense of it. But at the end of the day, these experts will provide insight and be able to lead this jury and teach and explain things to this jury, which is what you want. You want your expert in there teaching the jury because that's the point of an expert. Ask the judge, do they help the jury understand something that they wouldn't normally understand? That's their job. So, wow. So some great comments popping up already. I see them, and I'll get to them. But this is significant because this was just a preview of how this is going to go. Now, the jury wasn't there today, but the jury will certainly hear all the qualifications. The jury won't hear that they were hired by the federal government. They'll keep that kind of, I get something on my way here. I'm sorry. They will just hear that they were hired by another entity and they're not allowed to say that it was the Department of Justice and the FBI who hired them, which is fine. That might be better for the defense if they were allowed to say that. But who knows? Maybe some people on the jury don't trust or like the FBI or the federal government at this point either. So you don't know. So the real issue now for the Commonwealth is, how do I overcome this? I don't have a witness and I have to prove that it was her beyond a reasonable doubt. I need to prove it, right? Beyond a reasonable doubt. And can you get there if they believe the expert testimony that says, nah, it's not consistent. My opinion or our opinions are that no, the injuries and the damage here not consistent with what the prosecution is alleging. That's a wow moment. It's a wow moment because the absolute disparity between the experts. Now, here's the problem for the Commonwealth, and this was not expected, right? Because the Commonwealth would basically expect the defense to go hire somebody like they always do, right? Like they always do. But there was this independent investigation that was taking place by the feds. And then the feds turned over all their information to both sides. And then when both sides got it, the defense's eyes lit up like, oh my goodness, the federal government has hired these amazing experts and has paid them, and they've come to the conclusion that we want. Like it was a gift. It was a gift to the defense. So there's no way in the buildup before these things get into the hands of the parties, which is like, I don't know, February or March, just before trial, that the Commonwealth could have anticipated how bad this was going to be. but it is bad. It's really bad. Now, I'll address the other expert, the first expert, and I have it up right now. The expert who was talking to the so-called dog bite, dog scratch expert, doctor woman. If I was the defense, I'd stay away from her. I would stay away from her. She didn't exude confidence. She wasn't on top. She's fumbling with her words. It's a little messy. She doesn't have the credibility that these other two guys do. And I think it impacts the credibility of your case. If you just bring in this woman who is sort of saying, oh yeah, they're parallel. That looks like a tooth mark. That looks like, I think she'll get torn apart potentially on cross-examination. I don't even think her direct was strong. You can make the arguments that it's a dog if you want. You can use the expert if the defense wants to. They may still try to call her if the judge allows her to testify because the notice came in late. But her testimony was weak. It was weak. You have to be honest. You have to look at these witnesses and you have to be honest about them. And then, you know, if I'm the Commonwealth and I'm fighting to keep this witness out, I might actually let this witness in because this witness then reflects upon the entire defense case. Like who is this doctor? What is she saying? Really? Is she providing any expert analysis of this, or is she just looking at an arm and saying, "Oh yeah, that could be teeth, or that could be nails, or claws," right? Like she didn't know the word. She didn't know the standard. It's problematic to me, extremely dangerous for them to put her on because it reflects on the credibility of your whole case that you're making. You already have problems with the defense with the 227 call. You've got problems with that. You got to admit it, the defense. You have to acknowledge that because what I heard in the cross-examination of the expert yesterday is that the defense is going to try to undermine the expert who works for Celebrite by saying that perhaps the information that he was given had been tampered with. All right, now you've got to demonstrate how that was tampered with, and you're putting more of a burden on yourself with that. So the 227 Jen McCabe search that's in doubt for the defense. In what was going into the trial, the biggest piece of evidence, you've got to adjust because it's no longer the biggest piece of evidence for the defense. The Celebrate guy, he's not in the conspiracy. Did he lie? No, he just got there and told the truth. And he brought with him, and it's not just because of his English accent, but he brought with him a sense of experience working on all sides of this and understands and explained the search. Now, you may have your own expert. That's fine. You're going to bring in your expert, have that battle. But I don't know if you bring in a questionable expert like the woman who was voir dire this morning outside the presence of the jury, who was talking about the dog bite and dog scratches. Like, to me, if I have an expert like this, I would want them to come in and say, okay, all right, these are dog bites. How do you know? What type of teeth? What type of dog? You know, specific stuff that you're going to get from your engineers. She wasn't there. She's just looking at a picture, say, "Oh yeah, it looks like a dog bite," and the parallels that could be teeth, or that could be nails or claws. She said both. Is that expert, or is that someone just looking at a picture? I don't know. Unless they can somehow present her in a much better light than she was presented today, I would stay away from her if I was defense. But I'm not the defense, and if I'm the prosecution, right? And you're fighting to keep her out, go ahead, be my guest, let her testify, because I think the level of her credibility reflects on the whole case, just like the trooper's credibility reflects on the case of the Commonwealth. You know, an expert is great when an expert is an expert, but when an expert isn't an expert, it's bad. It's really bad. Like, this is the best you could do, Commonwealth, in explaining to us how these pieces are exploded like they are, and how his body is where it is, and his shoe. Like, no, that's That's problematic. It was not expert testimony. It was lightweight expert testimony in a case that means nothing. This is not that case. This case means everything. And he didn't have it. He didn't bring it. And he's going to be clearly outmatched by these two engineers paid by someone other than the defense to render their opinion. So that's where I stand right now. So after today's preview, and the judge still may not allow this testimony. I don't know. The judge has to make a decision. But if the judge doesn't permit these two engineers to testify and she gets convicted, this thing will be flipped and turned over before you can say Jiminy Cricket. Like, really? These are witnesses who as soon as their opinions became available to both sides, the defense said, yeah, we're going to call them. Why wouldn't we call them? And yes, the test for the judge is, do they help the jury understand? And absolutely, these two could help the jury understand. The doctor with the scratches, I'm not so convinced. That just sounded to me like someone who looked at a picture and said, oh yeah, I want more. I want you to, I want a greater level of depth to explain that as an expert, because we, meaning the members of the jury, can just look at the picture. They know what a dog looks like, and they can come up with their own explanations or own inferences from that. And you may not even need an expert for that. I mean, what that expert was saying about the scratches is what you could argue as an attorney, and what the jury can look at and make a reasonable conclusion from. Oh yeah, that could be a dog. Boom. That game over, right? So it is a rough day today for the Commonwealth, but it was outside the presence of the jury. They have a little bit of time to prepare for it, but how do you prepare for it? How do you prepare for guys that are just coming in and testifying based upon their vast knowledge and experience and expertise? Maybe you say, oh, you didn't see this piece of evidence. How about this piece of evidence? Did you consider her? And what I would do on cross-examination is say, well, did you consider her confession in coming to your conclusion? Objection. Well, prosecution is alleging a confession, and they had witnesses who said, she said, I did it. Whether you believe them or not is up to you, is up to the jury. But the evidence is in. All right. Deanna Bellina, I think they dumped this on the new guy, meaning the trooper, right? Well, here's the thing. And when he was explaining how he got the case, it was like he was just assigned the case. They didn't necessarily look at this case any differently in the preparation that they would with any other sort of accident type case. What the Commonwealth could have done is, and I don't know what their budget is, but they can go and spend money to bring in an outside expert. All your experts don't have to work for the state police. They don't have to work for the Commonwealth. The state very often, remember the Derek Chauvin case, they went out and found experts. They had to pay them. But experts get paid for their time. But actually in that case, I think they decided they wouldn't even charge them. I think they ended up not charging the state of Minnesota for that. But anyhow, you go out and you find qualified experts, and qualified, experienced experts who are experienced in testifying as well. How you say it is as important as what you say. And I think he failed on both. And it's not his fault. This is a big case. And, I was expected from the Commonwealth to bring in some engineers, honestly, to look at this. And that's where the defense is. And that's what the federal government did when they looked at this. They said, let's hire some engineers from one of the big firm, one of the big firms in the country that handles some of the big cases, because these cases are very common in courtrooms. I mean, all the time you are hearing from experts in car accident cases all the time, whether it's a deposition or inside a courtroom, all the time. So Commonwealth is going to lose this battle. There's no doubt they're losing the battle on the accident reconstruction. they're just going to lose it. So now, how do you mitigate that damage, and how do you present other evidence to attempt to actually win the case, right? Because you believe, and this is the only way you should be proceeding, you believe your theory is correct. So, Myron, I agree. Vinny, I don't think the defense will keep her. Yeah, I think this was a blessing for the judge to call this hearing before allowing the defense to call this witness. Like, don't bring her. She doesn't help. She doesn't help. She doesn't help. Nikki S., a gift from Nikki S. I think you're referring to the gift that was given to the defense by the feds, which was the federal investigation of the investigators, which they're the ones who hired these experts as part of their own investigation. But all that information then was given to both sides and ends up falling on the lap of the defense. So that's why I'm calling it a gift, if I am answering the correct question there, Nikki. Thank you so much, Nikki. And here's Sherry. I had dog bites that looked like scratches as the dog dragged his teeth on my arm. Right. So I don't think you need an expert for this, Sherry. I don't think you need an expert. I think these are the arguments you make. Ladies and gentlemen, jury, you look at it. You tell me what it looks like. I mean, do you need an expert who might come across as a little weak? And she wasn't really even cross-examined. She struggled. She absolutely struggled, just like the trooper struggled. So part of trial strategy is to try to draw as much of a contrast between you and the other side, whether it's a civil case, criminal case, whatever it is. And credibility is everything. Credibility, you as the attorney, you need to maintain your credibility. And you want your witnesses to be credible. But when you have problems with your witnesses, sometimes it reflects on you. If they're witnesses that you chose, witnesses that you hired, witnesses that you procured, then it falls on you. So when you make those arguments, the closing arguments, the name of my show on Court TV, at the end of the case, your credibility is in question. Well, do I really trust him? That's the lawyer who brought in that wacky expert, right? Right. So that's a consideration. You got to think about these things. So thank you, Sherry. Good comment. And I don't know, does the dog bite, like, and I know before the trial started, it was all about the dog. It was all about the Google search. But the Google search, you've got problems with that. That's not the cornerstone of the case. The case has evolved into a classic reasonable doubt case. It's just evolved. Like the conspiracy has not really, and again, we're not in the defense case yet, but still up to this point, it's not really been put together coherently with any smoking gun evidence. Like the smoking gun was the Google search. But is it still really smoking? Like, honestly, for those of you who believe in that, honestly, after listening to the testimony of the man from Celebrate and listening to the cross-examination of that witness, is it still a smoking gun? Is it? Because what I heard in the cross-examination of that expert was the defense trying to lay foundation that someone could have manipulated some things before you got it. Meaning, we can't really attack the credibility of this expert because, well, he's an expert. He knows what he's talking about. Like, this is his life's work. And, he's not lying. He's obviously not part of any conspiracy. He's like from England, moved to Canada, was a cop, then started working for Celebrate as a cop. He was fell into the digital forensics, and now does it for Celebrite, which is the software in the company that everybody uses, right? And everybody seemingly trusts, but not everyone understands. He does because he works for him. Like if he misinterprets the like he's the person you call. Like if you're trying to you're looking at this report and you don't understand something in the extraction, he's the one you call at Celebrite to explain it to you. So he's built with credibility. So the only way you attack his testimony is that he is basing his testimony upon something that was manipulated. And now, once again, the defense has added another layer to this conspiracy. Now someone has manipulated the phone data, and maybe they point the finger at Proctor again. I don't know, but someone's manipulating the data before it's given to the Celebrite expert to come up with his opinion, to provide his opinion. So we'll see. Okay, Kaz Stewart. I'm a huge fan of yours from Scotland. I saw an Instagram clip on Saturday of you with both of Karen Read defense lawyers, but can't find the interview. Help? Two places you may be able to find it. Now, this is before trial. There's no interviews during the trial because there's a gag order. But this is way before, right? When we started first, when I was covering the trial, pre-trial. You can check on courttv.com, or you can check on the Court TV YouTube page. What I'll try to do is I'll try to dig it up here if I can. I'm not today because I'm a one-man band and I just have to continue with the live stream. But those are the two places to check. And it would have been a while ago. It was a while ago. It was not like last week or the week before. You know, people take the old clips, they post them on Instagram. But yeah, the full interview. And in that interview, I said, really? That this Google search, 227, you're sure? And he was proof positive. I'm not proof positive on it, on the 227. I'm just not. Like, based on the Celebrite. Show me some evidence that somebody manipulated it, the phone data before the Celebrite guy got it, and then I'll think about it. But I'll still listen to their experts. But I'm wondering how their experts will know more than the guy who works for Celebrite. Maybe they will somehow, some way. Maybe their expert wrote the program. I don't know. But it's going to be tough to top the guy who works for Celebrite. But we'll see. Thank you, Kaz. From Scotland today. All right, what do we have? We've got Yobi Trice. Do you feel like the defense could not present their case at all and still come back with a guilty verdict? In my opinion, it feels like enough reasonable doubts and still come back with, I think you meant to say not guilty verdict there. In my opinion, it feels like enough reasonable doubt has been presented. And Yobi, what you've really jumped on here is how the system of justice works, right? The burden is on the prosecution. The defendant is presumed innocent until there is enough evidence to overcome that presumption beyond a reasonable doubt. Have they done that yet? Right? So a lot of times the defense does nothing. A lot of time. Here they're going to present something. There will be enough to get this case to the jury for sure. No doubt. But could they just rest without presenting any evidence and still make a strong argument for reasonable doubt? Yes, they could. But I feel like they want to put their experts in there because their experts are going to raise the potential for reasonable doubt immensely, especially the two who we saw a preview of today. That was not in front of the jury. Jury didn't hear any of that. So the defense needs to call those two engineers to the stand for sure. But great point, great analysis, Yobi. Thank you so much. Duty Ron in the house. This case involves a Boston police officer. You have your best men and women investigating, not here. The trooper yesterday was an embarrassment to all. He could not properly articulate anything. So right. As always, Duty Ron. By the way, folks, make sure you're subscribed to Duty Ron. Yeah. This is a big case. Now, I don't think they expected it to, and pun is intended here, to snowball to where it did. They didn't expect this type of aggressive defense. They didn't expect this 180-degree turnaround of the defense not just saying not guilty, it's just an accident, but saying, no, you guys did it. You guys in the house did it. So I don't think any of that was expected. Nonetheless, you would think and you would presume that when an officer is the victim, you would get your best and brightest, that you would give it to your top. I can't imagine that this is the top accident reconstructionist at the Massachusetts State Police. There's got to be someone above him, and whoever it was should have been handling this one for sure. And it should have been someone who has the confidence and composure to testify. I mean, that was a big spot. That's nerve-wracking. But when you're an expert, that's your job, is to meet that moment and meet that pressure. He didn't. 10 years from now, he may be able to, but he's not there yet. But that's who the Commonwealth put up. It is mind-boggling that they actually did. Thank you, Duty Ron. Yobi Trice, I meant not guilty verdict. There you go. I knew you did. I can read minds. See how important one word can be? Tishku. They destroyed their cell phones and got rid of the family dog. Things that make you go, And those are the types of arguments the defense can make without calling this dog bite lady. She's a doctor, dog bite doctor. I did not like the dog bite doctor. I didn't like her demeanor on the stand. I didn't like her word choice, her phraseology. She did not exude confidence. You could leave it at this. The dog's gone. Look at the arm. They got rid of their cell phones. Come on, folks. Something's going on here. Something's going on. And you can leave it at that something's going on. You don't have to prove exactly what's going on, although in his opening statement, Yannetti said this was a frame job. So I don't know how much they're going to pursue that in their closing argument, but we'll see. Thank you, Tishku. STX would love to hear Ben Chu's take on the trial. Indeed. Ben Chu, the amazing attorney for Johnny Depp. Thank you, STX. Dogs Discussions. YouTube loves Vinny and the tangents. Thank you, Dogs Discussions. I wonder what the Dogs Discussions has to say about, this. Does that look like dogs? Does it? You tell us, Dogs Discussions. You're the dog expert. Melly. Vinny, would bringing in the dog from Vermont, getting teeth impressions, compare against the wound, and wipe out this theory benefit the Commonwealth? Okay, and this is, thank you, Melly. Melly's also one of our mods, part of the mod squad with Frankie Figs and, of course, Gen X. When you're the prosecution, you have to be careful about being too defensive, right? And I think they've been too defensive throughout the presentation of their case because you do get a rebuttal case. So if things come up during the defense case that didn't come up during your case, you can address them in a rebuttal case. Laser focused. Maybe bringing in the dog from Vermont, maybe getting tooth impressions, maybe getting an expert to do that. I don't know if they've done that yet, but they could. And they would be permitted by the judge. If the judge permits the doctor dog bite doctor for the defense to testify, they'll have time to do this. It would be a powerful way for them to refute that testimony. Whatever they do, though, the impressions, everything, they'd have to provide to the defense. And once you take those impressions, you have to provide them to the defense. And then the question is, do they match? Do they not match? What if they matched? Then you just made the case. But as a prosecutor, you shouldn't worry about that. You should only worry about the truth. Thank you, Melly. Who else is here on this early day? Nay. Nay says he didn't use Celebrate, Vinny. He used his own program, not Celebrate. Defense has Celebrate in Google. Hi from Australia. Hey, Nay. Who's he? Who's he? Is he the expert that works for Celebrate? That was interpreting the Celebrate data? Or are you talking about Trooper Proctor? I'm not sure. We shall see if the defense has Celebrate and Google. We'll see. We'll see. But the man who testified for the prosecution works for Celebrate. He works for them. I mean, I heard that testimony. I don't think I'm hearing things. So we'll see. We'll see who their experts are and how they overcome it. But their cross-examination really seemed predicated upon manipulation of the data. That's what I heard. But we'll see. I'm basing everything now on what I'm hearing in the courtroom because I like to analyze this as the jury is analyzing this to understand where we are in this trial, in this quest for proof beyond a reasonable doubt. Are we there? Have they gotten there? What has the jury heard? So we shall see, Nay. We shall see. No strays ent. In your expert opinion, will Karen Read have to testify? Seems like she has a lot of explaining to do. In my opinion, she will not testify. She will not testify. They want this case for the jury to be about the credibility of Trooper Proctor, not the credibility of Karen Read. And once a defendant testifies, the whole case changes. The whole case changed. All that other evidence that came in, yeah, it's important, but doesn't even come close to the testimony of Karen Read. And I don't know how she would testify. I don't know what type of witness she would be. In court, there was at least one juror who got dismissed that did not like her, according to some reports. And if that's true, she's been very demonstrative inside the courtroom. So I think she would be that way on the witness stand. And it becomes more risky when someone is potentially angry about accusations and wears that. I want you to think back. And someone brought up Ben Choop. Think back to Johnny Depp. The one thing about Johnny Depp's testimony is that it was kind of like this. He was very measured and in control throughout his testimony. His laughs were everything. Even when he was talking about horrific things, there was a level of composure that the jury loved. Amber Heard did not have that. Is Karen Read more? Would she be more like Amber Heard or Johnny Depp on the witness stand? You tell me. You tell me. That's why I don't think she's going to testify. I think she wears her emotions on her sleeve, and that's just who she is. You have to understand who you are and who your client is and who you are as a person and how you are going to react when you are being cross-examined and how you are going to testify when having to talk about certain things. I think she stays off the witness stand. They keep the focus on Trooper Proctor, and they keep the focus on the burden of proof that is on the prosecution from the start of the case till the end of the case. That's my opinion. I could be wrong, because in the end, it is her decision. She is going to rely upon Alan Jackson and David Yannetti, but It is her decision. And I am not, some cases I'm preparing for a defendant to testify. This is not one of them. This is not one of them. It would be, from my perspective, the most shocking moment of the case if she testified. Michael Garnett, Trooper Paul was totally destroyed on cross, seemed unprepared. Couldn't the Commonwealth try and help him a bit prepare before it happened? Yeah. You're allowed to speak with your witnesses. You're allowed to do, talk to them about what the cross-examination might be like. I think it's a matter of experience. I don't think any level of preparation was going to help this expert for this moment in this case. I think he needs more experience. I think the most experienced accident reconstructionist in the Massachusetts State Police should have been the one doing this case, doing this analysis, and ultimately testifying. And that did not happen. But yeah, they are allowed to prepare witnesses. But the defense can ask about that preparation on cross-examination. So it's always a balancing test. How much preparation do I want to do with this witness? Because whatever I do now, the defense can ask about and the jury will hear about. Sin N, I'm an ex-Apple and ex-Google. There could be many issues with the data. All the Cellbrite software can do is rely on the hardware, logos, iOS, Android. Yes, I get it. But what I'm trying to understand here, and the way I see the issue framed, is trying to explain that readout that says 227 is the time for the search. That's the defense says 227 is the time for the search. And what we've heard from the two experts who've tested for the Commonwealth is that the 227 is not the time of the search. So obviously the defense will have an expert who says 227 is the time of the search, but I don't know. I think the defense will make a lot out of the deletion. I think that's an issue, but really for me as a juror, what I am most concerned about is just like 227, was the search done then or not? And then I'm done with it. If it was, then I'm sending Karen Read home. If it's not, then let's continue with the trial. To me, that's how that issue plays. And that's why it's so important for the defense and the prosecution, because it could literally end the case. But I don't think the defense is there. I think they've got a huge hill to climb now after the experts for the prosecution. Gloria, hey Vinny, what's your take on the arm wounds? Really from a hit and run? I look at it. What I still don't understand, and what I want to hear from an expert, and I didn't hear, is how the taillight shatters upon impact. The impact of what? And then how these marks are then made by the taillight. And that story wasn't told in a way that made sense to me by Trooper Paul. So what am I left with? I'm left with, I don't know. I don't know. Is it from a hit and run? I mean, first look at it would be, you would say no. I think most people would look at it and say, no, it doesn't look like it. That's why you need a really good expert to test them. And they may have one. They may have one to match it up and have it make sense. Something they need to do, because Trooper Paul did not do it. But I'll be honest with you, the dog bite doctor wasn't doing it for me either. Like, to me, it's still like, look at it and make up your own mind based upon your own experience and own common sense, which is where this jury may end up on this issue. Lauren Katie said, Paul said it shatters by his elbow. All right, that's what he said. Okay, well, if a car is hitting your elbow and enough to shatter it, would there be other injuries on the elbow? Would there be Would you expect to have broken bones? I don't know. Maybe not. It's wishy-washy for me. Wishy-washy expert, not good. An expert who can't articulate his opinion, not good. An expert who doesn't have the level or degree of specific expertise to deal with this scene is not good. And what I saw today from the defense, not their paid experts, but the witnesses they're going to call who were hired by the feds, seem to have those two levels of expertise to deal with the car and deal with John O'Keefe, and then put that together to tell me a story about why that did or did not happen as a result of a car going backwards. Gen X reminding everyone tonight, 8:00. 8:00 tonight, closing arguments. Yes, we'll be talking about this case tonight. And I think we're also going to get into little Soraya missing. Another case out of Pullman, Washington, and Moscow, Idaho. We'll get into the latest there. That one, we'll do a stream on that soon. That one will get you angry. That one will get you really angry. Let's see what else we have here. Lisa Marie, those experts this morning were for the defense. They're defense witnesses, correct. But they were paid and found by the feds who were doing their own federal investigation here. All right, here's a question from Jimmy H. So much reasonable doubt, but Vinny still thinks Commonwealth winning? Winning? No, not winning. Not winning right now. Losing in a big way. Need more. Need much more. Much more. First of all, to explain the scene better. Number one. Number two, to erase the doubts, right? Because the doubts are being raised in your case. You need to erase them in your case. See, like the defense is not raising the doubts right now in their own case. They're raising it in your case, which is a problem, which is very problematic. Now, I don't think the defense has proven any conspiracy, but now we're left to wonder, could it be a conspiracy? Is a conspiracy a reasonable alternative explanation to all of this? Have they proven to me really that the car struck him? Have they proven that to me beyond any reasonable doubt? No, I don't think they're winning right now. I don't think the case is lost, but they need to do more. They have the burden. She is presumed innocent until that burden is overcome. So, not there yet, Jimmy H. They're not there yet. Lauren Katie, let's be clear. I don't agree. Of course you don't agree. We're being very clear here. Okay. This is the revolutionaries. Love the glasses, first of all. As a person who's been attacked by a big dog, I disagree with you, Vinny. Those are 100% dog bites. They were exactly like the ones I suffered 36 years ago from Black Lab, and she looks good from my... Well, here's the thing. You're analyzing the evidence. I'm analyzing the expert. So I think we're talking about two different things. So with you, I did not opine what this does or does not look like. right? I opined about the expertise of the proposed expert, the credibility of the proposed expert. She was not a strong witness, period. End of story. You can put an expert like that up on the stand and then, rely upon them in your closing argument. But is the jury going to feel comfortable with that expert's testimony? Is that expert going to teach this jury? Is that expert going to control the courtroom? She didn't control it this morning. Trooper Paul didn't control the courtroom. An expert has to control the courtroom and the content of what is at stake here. They're the expert. There should be no one in that courtroom who knows more about what they're talking about than them. And I wasn't getting that from the dog bite doctor. You revolutionaries might be a better witness based upon your own personal experience. Because that's not the way she testified today. But thank you. Deb H. Nay, Celebrate Guy also uses his own software. So he's writing his own software. Yeah, he's using his own software, but he's interpreting the Celebrate report that came out that said 227 is the search. That's what is in front of this jury. And that's what the defense wants to put in front of this jury. 227 was the search according to this Celebrate report that we had to fight to get from the prosecution because they were hiding it. That was the initial allegation, that they were hiding this information. And that's why the defense thought it was so significant. It turned out that the Commonwealth had the wrong version of the software, which is another problem, another mistake by them. And that using his own software makes him even more credible. That this guy writes his own software, right? I mean, doesn't make him less credible. But it's all about the interpretation of this report from the industry standard. Thank you, Deb H. Mm-hmm. All right. This is interesting. Dogs discussions. YouTube says the scars look very old. See, now you get it. That's a forensic pathologist has to testify about that, about the age of an injury. Interesting. Very, very interesting. And that would be a forensic pathologist. An accident reconstruction is not going to talk about that. That's the pathologist. Haas Long. Trooper Paul was totally destroyed by Action Jackson yesterday on the stand. I was even embarrassed for him. Action Jackson was a movie. There were also action figures back in the day of G.I. Joe. I may have some Action Jackson figures that I don't have them handy right now. But thank you, Haas Long. I wonder which side you're on. But anyway, Trooper Paul it was a rough cross-examination, because what you take away from it is that the lawyer knows more about this than the expert. Problem. Major problem. Hey, got to listen to SW 4x4 Explorers. Be sure to show your love to Vinnie Politan and smash that like button. Come on. Smash it. We got more than 5,000 watching live right now as we simulcast on YouTube, Facebook, Twitch, and X. If you're on Facebook, please share it and make sure you're following me. If you're on YouTube, you smash the like button. Make sure you're subscribing. Trying to get the subscription numbers up. If you're on Twitch, you Twitch. And if you're on X, you re-exit or retweet it and make sure that you're following me there if you just came across it. But thank you, SW. Appreciated. Okay, Aaron Wilcott. So I'm really interested in what Vinny would do differently than Lally. Okay, first thing I would do is I would ask my questions much more simply. I believe, and it's kind of the way I do a lot of the interviews I do on television. I sort of incorporated part of what I do as a prosecutor. So as a prosecutor, when you call witnesses, you want your witnesses telling the story. And you want it to flow, and you want it to be a kind of back and forth. So your questions are short, limited, open-ended, and you're just basically pushing the witness along, telling the story. That's the first thing I would do, because I think it would be much easier for the witnesses and for the jury to follow everything. What did you see? Then what did you see? What happened? What happened next? And then what happened? Okay, so you finished doing that. Then what did you do? That would be more of the mode. And there are times where obviously you can't ask questions exactly like that, but that's the mode of the questioning that I would do. It would speed up my witnesses, number one, and it'd be easier to follow. I would do that differently. Also, the overall presentation of this case, I would have, for the most part, narrowed it. I would have cut out some redundant witnesses. I would have focused just on proving my case, not disproving a conspiracy. I would have saved that for my rebuttal case as much as possible. Obviously, some things come up during cross you have to address. But I would have had a quicker case, a more narrowly focused case in chief, and then saved more for my rebuttal case, and not been so defensive about this alleged frame/conspiracy case. That's generally what I would have done differently. Big picture. Thank you, Aaron. Let's see who else is in the house today. By the way, big thank you to Gen X, Frankie Figs, and Melly, our mods, Vinny's Angels, keeping law and order. And here she is. Rhino Girl is back. Trooper Paul is an expert in stuff. When asked by Jackson, what do you mean by that, Paul? I don't know. Love and support from Dubai. That's the problem. That's the problem. Big note here from Gen X. Let's scale back personal insults, folks. This is not a place for personal attacks. This is a very divisive case, as many cases are. As you're seeing inside the courtroom, there are at least two sides to this story. We can disagree without being disagreeable. A vigorous debate is healthy. That's how we get to the truth. But making it personal and turning it into personal insults is counterproductive and actually impacts your own credibility. Like if you resort to name calling, that decreases the value of what you say and decreases the potency of your arguments that you're making. So thank you, Gen X. Oh, it's not poisonal. It's like in The Godfather, tell Michael. It's nothing personal. It's just business. Just business. The business here is debating a case that is very debatable. Most trials are. Most trials have at least two sides. Jimmy H asking me the same question. I think I answered that. I would more focused, scale back in my case in chief is what I would do. All right, let's see who else is here. Let's see. Okay, so here's Nancy. But when Mr. Jackson attempted that question flow this morning, the judge gave him pushback for leading. Okay, so here, so if you call the witness, right, you cannot ask a question that suggests an answer. Okay. So you can't lead your witness to an answer. You have to ask open-ended questions and let them provide the information. On cross-examination, you can lead. You can ask a question that suggests an answer. Isn't it true? Isn't it true, Nancy, that you were watching closing arguments last night at 8:00? And isn't it true you were sitting on the couch and enjoying 2 hours of live television? Isn't it true? Right? So that's cross-examination. Direct examination is, Nancy, so what were you doing last night? And at what time were you doing that? And where were you when you were doing that? And where were you sitting when you were doing that? Okay, that's the difference. That's the difference. Hope that makes sense. All right. Here's comfort and joy. John's phone stopped moving after he was hit and fell at 12:32. That can be an important fact. That can be a very important fact. Now, I believe the defense has their own Apple health data that may contradict that. And then it'll be up to the experts and the jury to figure that out. But that's why this case is not over. If prosecutors can prove this through credible evidence and the jury buys it, that's very persuasive. To me, the timeline is still somewhat fuzzy. It's still somewhat fuzzy at this point. Oh, Michelle L., this was a moment. Trooper Paul Slip, he said, I don't know. I didn't put it there. Alan Jackson, no, you didn't. And then Alan Jackson got admonished by the judge because obviously in that exchange, the trooper, the expert, is saying, well, so is asked, how did the stuff get there? And he says, I don't know. I didn't put it there. And then you shouldn't say that, number one, as an expert. But then it opened the door wide open for Alan Jackson to say, no, you didn't put it there. And the judge, come on, Mr. Jackson, you know better. You know better. But that's the argument Alan Jackson's going to make in his closing argument, is that everything was put there. And as part of the frame job, here's, I think the strength right now of the defense case is Trooper Proctor. That's the strength of the defense case. Usually that would be the strength of the prosecution case, your lead investigator. A lot of times it is. In this case, it's not. So that's their best avenue, and I think where their focus will be when it's time to try to convince this jury. Your lead investigator has many problems, many problems. So what is the strength of the prosecution case? Well, the strength is the alleged confession. The strength is she's the last known person to be with him, right? Like, we know that he was in her car. The rest of the strength of their evidence is the DNA, the pieces of the taillight, the shoe. All of that is strong evidence for the prosecution if you can overcome the problems you have with the lead investigator. So it's a balance. So that's why I believe the defense's strength is Proctor, because it undermines the strength of the prosecution case, which is the evidence that he gathered. Look at this. Cayenne zone. That is a great photo. I really like you in this format. Thank you so much. I really like you in that photo too, by the way. Cayenne Zone. Eladia Lopez. I usually just come to listen to Vinny. I just love him. Thank you, Eladia. Eladia. I think it's Eladia. It should be Eladia. I never took Spanish, so I'm guessing. All right. Justice for Matthew North. Okay. She called holes in the shirt wounds. She stuttered, not a strong expert compared to what the state has put on the past few days. She was problematic. Her word choice, her verbiage, her command, the confidence, her word choice, and what she actually looked at here. Here's a problem. Something else came up at the end of her voir dire today that I think is extremely significant. She's on record as to what she looked at to come to her conclusions, but she was sent a lot more information by Alan Jackson. So Alan Jackson now is stuck, and the defense is stuck with a witness who was sent a lot of stuff, but a witness who only looked at part of it. And that's a problem. That's a problem. That's why I think they may not call her. Corina Pinky Woolgar. Corina, I love that you're doing a Facebook Live. It's my first one, and I'm loving it. Yes, and it's a simulcast. It's Facebook, it's YouTube, it's Twitch, and it's X all at once. And we have over 5,800 folks watching right now. So thank you so much for finding us, Corina. Make sure you're sharing and following. Okay, Tom, CPU. We love you, Vinny. What about the missing 45 minutes of Sally Port video? Another problem. It's a huge problem. This doesn't make any sense. And here's the problem. A lot of times in a lot of these cases I've covered through the decades at Court TV, there are police departments that might be a little small, a little sloppy, not ready for prime time. They don't, and it's for a good reason. They just don't get a lot of murders in their jurisdiction, which is a good thing, right? Because that means it's a nice neighborhood. It's a nice town. But this is a real problem. Like, video looks like it came from a early 80s VHS, right? It's horrific video. And it's like the two pieces of video that we want to see that would clear up a lot of things are missing. The 45 minutes from the Sally Port, and then the other videos from John O'Keefe's driveway. Like when she returns at 12:41, when she's there with the other two women looking at the taillight. Like, these are major, major problems. These are things the jury would want to see, and now you have to explain to the jury why they can't. And when you've got the other side alleging conspiracy, bias, etc., it becomes even more of a problem. It's not just sloppy police work. This now potentially is intentional conduct. And if the jury doesn't have to believe it beyond a reasonable doubt, but if believes that's a reasonable explanation for why this is missing, that they're getting rid of it, if they believe it's a reasonable explanation that the driveway video is missing because someone deleted it from law enforcement, then you've got reasonable doubt. If someone believes that's a reasonable explanation for why the jury doesn't get this evidence that would clear up a lot of things. It's a problem. Thank you, Tom. All right, Ashley Oaks. Judge Bev seems so rude to the defense, always cutting them off. So let me give you some insight into, and we're over 6,000 live viewers. Thank you, everyone. Amazing. So let me give you a little insight into how the world works in courthouses with judges, etc. Every judge in every courthouse has some sort of a reputation. And if lawyers are honest with you, they'll tell you, oh yeah, that judge is always tough on the defense. That judge is always tough on the prosecution. And they exist. When I practiced, there was one judge, it was automatic. As a prosecutor, whatever the issue was, I'm winning. I'd go in there knowing I'm going to win. I still presented everything I needed to present, but I knew I was going to win. Then there was another judge who was the exact opposite. So I had to work 10 times as hard just to stay afloat. And judges have reputations. And I don't know going into this what her reputation or background was up there. Next time I go up, I'll ask. It's hard to get an honest answer because people are afraid to tell me. Like especially lawyers who have to appear in those courtrooms and courthouses. They might give you anonymous information, but many of them are afraid to talk about judges' reputations. But if you practice there, then you know. So this may be the norm. It may be the way most defense attorneys are treated. And I think most people have gotten that. Now, the other thing that happens, though, you have to understand this as well. In a lot of cases, usually the defense is the one pushing the envelope inside of a courtroom. Not all the time, but it's the more normal course of events that during a criminal case that a defense attorney will push the limits of the rules of evidence, will try to get things in front that maybe don't normally get in front of a jury, or ask questions or say things or do things that are, the best way to say, pushing the envelope, because that's their job, is to vigorously defend their client. But sometimes that comes into conflict with the rules of evidence and everything else that happens inside of a courtroom. So that's why in many cases, you'll see defense attorneys generally getting into a little more trouble than prosecutors in front of judges. But it's also the opposite, depending upon the judge's perspective. Judges come to the bench. They're not anointed from God and placed down as independent arbiters. They're put there. They are human beings who see things through their own filters. And that's how they act and react to situations in the court. And that's just the truth. That's just the truth. And I don't know if other lawyers will say that because they don't want to offend judges. My father was a judge, and he was very transparent about how he became a judge. And that, there are judges see things the way they see them. It is what it is, right? So, and I think that may be what's coming out here. She may lean a little bit more that way. She may be more skeptical of defense attorneys in general. And this defense team may have pushed the envelope a little harder than other defense attorneys have pushed them in her courtroom, and she's pushing back against it. And that may be the vibe that you're getting, Ashley, and that may be why. I hope that clarifies it to an extent. But everything is on the record. So a judge knows or should know not to cross that line that would put in jeopardy a guilty verdict if it happened, which is why judges often will, even if they're like, oh, okay, go ahead, make the calls that way. So we'll see. Okay, Dolores Del Signore. Nicholas, I think she spends too much time in sidebars with the lawyers. If I was on the jury, it would make me a little upset. I want to know what's happening. That's true. I just served on a jury. There were a few sidebars. You're curious, but here's what's happening in this courtroom, which is interesting. The objections are just being made, like objection, sustained or overruled, right? Period. The person making the objection doesn't even give the basis of the objection. So there are no speaking objections allowed in front of this judge in this court. But if one of these issues comes up and they have to explain why they're objecting, then you got to go to sidebar because you're going to talk about things that you don't want the jury to hear. So that's what's happening. It's legal decisions that the judge has to make outside the presence of the jury. And, some judges allow a little bit more in front of the jury in terms of the objections and the rulings. This judge wants to keep it very pristine and wants to shield the jury, which she's entitled to do. But I agree that when you're a juror like I was recently, you want things to move along. You want things to move along. You don't want to spend too much time in the jury room until it's time to deliberate. You want to get in there. You want to get your work done because you want to get home, because you know you still have to work, take care of your family. Life goes on for you. Thank you, Dolores. Dolores always has good insight and good questions. Loving it, loving it, loving it. All right. I got to keep an eye on the clock, by the way. I am on the clock. I'm a working man. 8 o'clock tonight, we'll be talking about this on Court TV. Rhino Girl, best comment from Action Jackson today, in my humble opinion, is I did enough damage already when asked if he wants to recall Jennifer McCabe, a witness, Jennifer McCabe. He throws him in there. He's quick. He's quick. Action Jackson is quick. He's smart. He was smart when he was a prosecutor, and he's smart now on the other side. Great comment. All right. And we've got Meg, who's on Facebook. Much love from the UK. Thank you, Meg Jane. Appreciate it. All right. True After Dark. Maybe John was actually hit by the snowplow Jeep. Just saying. Some people put that out. Some people have talked about that. The snowplow. You know? Now she said, Karen Read said she saw him go up to the front door. So if it's a snowplow, he'd have to go up to the front door and then come back out at some point. But no one inside said that he ever came inside. So he'd have to go up to the door. Karen Read would have to leave. Then he'd have to come back, maybe fall down, stumble, knock his head, get hit by a snowplow, or get hit purposely by a snowplow, by someone who had a snowplow there that night. We'll see. But I don't know if anyone's going to argue that. But if you're thinking about it, the jury might be thinking about it. You see, you can only make arguments to a jury. You can't control their thoughts. And they are allowed to use their common sense and come to whatever conclusions they come to. Judge Bev insists on moving the trial along, but she keeps 9 to 4 hours, half days, and too many days off, says Jade Roscoe. Well, Wednesday is a holiday. The half days, I believe, are to do other court business. Now, here's the other thing. You're a judge. You have a big trial like this. You still have your docket, and you have people making motions and pending cases. You have violations of probation. You have other matters you have to take care of. In New Jersey, where I practiced, you would do the trial 4 days a week. And then Friday, the judge would take care of all of her other business. But yeah, they got to keep it moving along. But yeah, they've missed some days here. There've been some half days. But a judge generally has other matters still ongoing, even when you're in the middle of a big trial, which is why most judges try to get the parties to plead the case out so the judge can clear off her docket. But it wasn't happening in this case. Thank you, Jade. Great observation. But even without the days off, it's still been a very long trial. But I would expect that in Massachusetts. Massachusetts trials are longer. California trials are longer. Florida trials are generally shorter. New Jersey trials are much longer. Some states, it's amazing. You could take the same case, put it in 4 states, and it'd be 4 different lengths. Like someone would be like, whoop, whop, boom, we're done. Other states, it takes a while. JH, if the Commonwealth asks questions leading to FBI involvement, like what happened today, does that open the door for all the FBI investigation to come in? We'll see how that door could be opened. When those experts testify, they're going to be dancing on the wire because they're not going to be mentioning that. But will the prosecution open that door? I'm sure the defense wants that door tossed open. They clearly do. I know the judge doesn't want any part of it coming in. And obviously the Commonwealth doesn't want it in. So the Commonwealth has to be careful here. Commonwealth has to be very, very careful. And there was a question today that brought up the FBI. So if that comes up in front of the jury's going to be like, what? Wait a minute. Why is the FBI? Then I think the jury deserves an explanation as to why the FBI would be involved in this. Like, absolutely. Great point. Thank you, JH. Val Daca. Vinny, please just tell us the truth. Does his arm at the picture look like the taillight did it? Please, I really want your personal and honest opinion. Val from Michigan. Does it look like it? Not from impact. It would have to be broken first. There'd have to be jagged edges of that tail light. I always thought the glass may have had something to do with that. I always thought maybe there'd be an argument about the glass, but it's not. So you've got these punctures in the shirt, to me, that say you need a jagged edge, and obviously you need a jagged edge to do that. So there'd have to be a subsequent impact after initial impact. And I wasn't buying, I didn't follow or really like Trooper Paul's explanation for that. So I'm not convinced right now on any of the evidence. Now, if I just look at it, it looks like it could be in conjunction with the punctures on the shirt. It needs to be something sharp that is able to cut through a sweatshirt to get through. Which would seem more likely to be teeth could do that versus being impacted by an intact tail light. Like, wouldn't you bounce off the car and then there has to be some second impact? Like, I always thought the argument was going to be that there's the initial impact of the car, a broken glass that is part of the second impact. As the body's hitting the ground, it hits the glass. I thought that's what the explanation was going to be. But it wasn't. So it's problematic. So that's where I am on this. Be interested to hear the two experts who were voir dire today that were hired by the feds. I hope that gives you a little more clarity, Val. All eyes on Delphi. Defense should drop the conspiracy theory and just stick with Proctor's bias. All paths to guilty verdict closed after Trooper Paul's testimony. You may see a little bit of a pivot from the defense. They may not lean into that overall frame conspiracy as much in their close as they did in their open. I mean, things develop in a trial and take form inside the courtroom in a certain way. And I think we're all in agreement that it's about Proctor and his bias is really like that looms large in the courtroom. And that's where you really have to focus the case. If you're representing Karen Read and if you're representing the Commonwealth, if you're the prosecutor, you have to deal with that. And you've got to win despite that, because that bias was absolutely clear. Absolutely clear. You have to, have a moment of truth in the mirror and say, yeah, that didn't go well for us. I'm going to have to overcome that. Michelle L. Why are no speaking objections allowed, Vinny? That's the judge's courtroom. Judge makes the rules. Some judges allow it. Some don't allow it. This judge does not allow it. That's why if they have to get into the nitty gritty of an objection, they have to do it at sidebar or send the jury out of the room. But it seems even if they send the jury out of the room, they still do it at sidebar. They don't want us to know about it. And that's probably the cleanest way to run a trial. Because when a jury is exposed to some of that stuff, they might hear something that they shouldn't hear, and it could become an issue if there's a conviction and when there's an appeal of that conviction. So I think it may be her standard operating procedures just to keep her trials as clean as possible, to keep that stuff away from the jury. Eladia Lopez, what's it like to serve as a juror with your experience as a lawyer? It was eye-opening. It was fascinating. It was not a criminal case. It was a medical malpractice case. And the takeaway for me was the experience was much different. So I've been in there as a lawyer and an advocate, right? As a prosecutor, as a civil attorney. I've been in there for years as a legal analyst and journalist. I've never been a witness. I'd like to do that as well someday. But I always wanted to sit in the jury box. And once you sit in that box, for me, the difference was the connection to the people in the case, the emotional connection. Like I wanted to do the right thing. I'll let you know, I didn't get to deliberate at the end. I was an alternate. So yeah, I went to the prom, but I went with my cousin. There's a connection that you feel that is real. And you feel, this was a medical malpractice. So the plaintiff, who, I'm not going to tell the whole story now, I'll do it again another time. I felt bad for him. I felt really bad for him. He was a good man. He was a good, hardworking man. And I felt bad for what happened to him. But then the doctor who was being sued, I was like, this man is such a gift that we have someone with his level of skill, that he can do what he can do in such a pressured situation. So I was floored and impressed and in awe of this doctor, while at the same time I felt so bad for this man. And I didn't expect that emotional connection to the people in the case. It's just amplified immensely when you're in the box. At least for me, that was my experience. And that was the biggest surprise and shock for me. Kim Bullock, those scratches look like drag marks to me, like a body that was dragged across gravel and broken glass. And that's, Kim, that's what I thought they were going to say. I thought they were going to say, impact one knocks him down. The truck continues. He is now pushed and dragged. He was holding a glass. Exactly, Kim. That's what I thought was going to be the prosecution's case, but that's not really where the trooper took us. Nurse Kim, please consider having Dave Cullinane and I on. Ooh, Nurse Kim and Dave Cullinane. All right, I write it down every time, but I haven't written down Nurse Kim. Dave Cullinane. You know, go to my Twitter. Send me a DM on Twitter. DM on Twitter. That's the best way. A direct message on Facebook is crazy now, because every time I go live, there are thousands of messages, and there's not enough time in the day. So that's actually the best way to reach me, is DM on Twitter or LinkedIn. All right, we're almost out of time, folks, but JH, John O'Keefe, 6'2", and TP said he was standing with his arm up. His analysis showed that it's physically impossible for her taillight to hit him, according to the Commonwealth. Arm up, 6'2", taillight of an SUV, a Lexus. Yeah. The one thing I will say about the arm, though, I could see it as it's almost like a defensive wound is the way he's describing it, right? It's like the car's coming at you. You put your arm up as a defense mechanism. Same way we see people put their arms up when someone's coming at them with a knife, or sometimes when someone's being shot, they'll put their hands up. Yeah, but does that work? Does that work? We may hear a little more from the defense experts on that. And that's the kind of stuff the jury wants to hear, because that's the kind of stuff the jury heard in the Alec Murdaugh case. Andrea, anti-everything. I deliberated on 2 Massachusetts jury, 1 med mal and 1 child abuse. And even though the defendants were technically guilty In our personal opinions, the Commonwealth failed to prove beyond a reasonable doubt, so both not guilty verdicts. And that's what you should do, Andrea. That's exactly what you should do. And that could happen here. The jury may not think there was a conspiracy, but they may think, yeah, something could have happened here. Yeah, she probably hit him with her SUV, but we're just not convinced. So you applied the legal standard because our system is set up to let guilty people go free before any innocent person is ever convicted. Thank you. Andrea, anti-everything, being on med-mal, jury broke my heart. I sobbed. Yeah, those cases are tough because in most of the cases, like the doctors are, in most cases, there's exceptions. At least I know in this one, the doctor's is highly trained and experienced and is really trying to get the best result possible for the patient, especially like in an ER situation like we were in. Cindy J, what will the medical examiner say the cuts are from? I'd say consistent with the taillight, broken taillight, the glass. There's some ground that needs to be made up now by the prosecution, by the Commonwealth. Run the world. Would you have pursued a case when you were a prosecutor if the feds said the alleged perp didn't do it? Interesting, right? Interesting. Is there more? Well, I think you need a little more information. Why are the feds looking at the case? What is the relationship between the federal prosecutors and the local prosecutors? Are there any politics involved in this? And what is the basis of them saying the alleged perp didn't do it? So applying it to this case, my understanding is that there is a little bit of friction between the local prosecutor and the first the U.S. attorney who began this investigation into the locals. My understanding, there's a little bit of animosity between the two offices, that may be some politics involved. So I think that would be their explanation for why they continue to pursue this and don't believe anything that the feds did. But me personally, I think it's fact sensitive. But if I was provided with any evidence, any credible evidence that the person didn't do it, you can't pursue it. You can't. Summer Golden, hey V, still don't understand how this made it to trial. I believe KR is innocent, Karen Read. It is clear the attorneys believe in her innocence and they are running circles around Lally, which is fun to watch. It's interesting. As a young prosecutor, I won a case against a defense attorney who was much better, much more experienced than I was. Don't know if he ran circles around me necessarily, but clearly, knew much more of what he was doing. So that doesn't always make the difference, but I believe in a case like this, it very well could, Summer. I think it could. Now, you have to be careful. This is where you have to be careful. You don't want to be overconfident or arrogant. Jurors hate arrogance. So if they feel like in you running circles around the other, you're exuding some level of arrogance, you got to pull it back. Stay humble. Stay humble. Fight your case, but don't be smug. I think that's a trap that I've seen some attorneys run into. So they've got to be careful. Got to be careful about that. Jurors are judging you every moment of the trial. Caius Posthumus Tarunus. You see a reaction when they said he did a 180. Yeah, I did. Caius Posthumus Tarunus. Did I just say a dirty word or something? I don't even know. But thank you. Yeah, her reactions throughout this are something. And this is, I don't see how Karen Read is innocent at all. So you see, things are split here. This is not as much as both sides believe this is an open and shut case. It's not, because you've got two sides both saying that. All right, this is an interesting one. Sunshine. Mystery singer. Who is this mystery singer? Who is she? Who is that? When Karen gets acquitted, the FBI will indict the Albers, Trooper, Proctor, and Tully with their 3,074-page report. I don't know. We'll see. We'll see what happens. I don't think so, but maybe. All right, folks. Here's the situation. We've got over 6,600. I think we got close to 7,000 today. Crystal Morin, just tightening up. He used his own program, talking about the 227 expert, to render his opinion, though. Yes, but it's his opinion about the report, right? It's his opinion about the report from Celebrite. So I get what you're saying, but what is really at issue is this guy an expert in how Celebrite works and what it means? Is he? I think the answer is yes. And I think and he's not the only, they had two experts, by the way. They had two experts. The other one, I mean, she knew what she was talking about also. Where is the opening? Where is this opening for the defense to convince this jury? Not just that, oh yeah, maybe she Googled a 227, but like, no, she Googled a 227, Karen Read walks out the door. That's not there. And both these experts, their conclusion was their conclusion. So how do you attack that conclusion? You got to look for that opening. And from the cross-examination, I don't know what their experts are going to say, but from their cross-examination, it seemed that the defense was going down the avenue of the expert from Celebrite was given tainted data. That's where the cross was going. Now, with their own witnesses, they may take it in another direction. That, oh, well, he did this, but he shouldn't have done that because that doesn't make sense because this is what he should have done, or this is how he should have interpreted it. So we'll see how that plays out. But there was the way that Trooper Paul left that witness stand is not the same way the two experts on the Google search left the stand. Two different situations. In one, the Commonwealth is winning, and the other, the Commonwealth is losing. I hope you're following that. So I get it. All right. I've got a big meeting I've got coming up. I got a big show tonight at 8:00. If you're on YouTube, please hit the like button. Please subscribe. Let's get the subscription numbers up. Facebook, share, Twitch. Just Twitch it. Twitch numbers are actually have been up a little bit. And on X, you've got to re-exit, retweet it to spread the word and make sure you're following me there as well. I may be doing one tomorrow night. Okay. Tomorrow night, I may be doing a stream when I usually do my television show. So I'll know in a little while, but I don't think I have a show tomorrow because of the federal holiday. So get ready for tomorrow night right here on YouTube. In the meantime, thank you for watching. Thank you for supporting. I'll see you at 8:00 on Court TV. In the meantime, have a great day. And don't forget to hug the kids.